I don't know how well you guys will be able to hear me. However, I'm going to do my best to articulate to you the importance of Maxims. And last night I did a little ditty on Maxims. Again, it's something that helped me tremendously as I started to strive away from statutes, codes, city ordinances, rules, and regulations. When Mr. James Bethel gave me the Maxims, he gave me a bunch of books. Each of them's got like 13 to 16,000 Maxims in them. And I first started reading the Maxims, and I was filled with delight and joy because it resonated with my mind, body, spirit, and soul. The Maxims were just so poignant, it couldn't be argued. And it was only later that he explained to me that the reason those resonate with you so well, Derek, is because you have been raised to be an honorable man, a righteous man, if you will. And so some of these Maxims will resonate with you while others do not. As I continued to read through these books of Maxims, I eventually got to Roman civil Maxims. And I got to some that just pissed me off so bad because I said, this is just like statutes and codes. In fact, I was so pissed, I called James up and I said, damn it, James, it's the same shit, just a different jurisdiction. He goes, no. He says, as far as the different jurisdiction, you are correct, but it is not the same stuff, all right? And he explained it like this. The Maxims that you are reading now that don't resonate with your mind, body, spirit, heart, and soul are that of which of Roman civil Maxims. Roman civil law. Roman civil Maxims. They replicate and duplicate equity by nature. And that's why you're struggling with them. Because they're not true, accurate, and correct. They're based on commerce, those Maxims. So, I don't know how well you guys can hear me, but I'm going to do this little video here. And we're going to go through a list of Maxims again, because I think it's important for people to ascend of the mind. A lot of gurus out there, but ain't nobody really talking about 20 Maxims, you know, and I know exactly where they got that list of 20 Maxims because I've had a number of conversations with the men who showed me where to find them. And those 20 Maxims do set precedent. Make no mistake about it. But why just arm yourself with 20 sound doctrines and principles? Why not have a plethora of Maxims to reach for? Common observance, words, terms, phrases, etc., and their construction is not to be departed from. Things do not change their ownership when captured by pirates and robbers. Accept from others the same treatment that they receive from you. No injury is done by things long acquiesced in. We must call him absent who is not in the place in which he is sought. To accept anything as a reward for doing justice is not accepting but extorting. An action is not given to him who is not injured. An act done without my consent is not my act. An criminal act itself does not make one guilty unless done with guilty intent. In order rightly to comprehend a thing, inquire first into the names, for a right knowledge of things depends upon their names. Equity remedies errors. Equity is a kind of perfect reason which interprets and amends the written law, comprehended in no code, but consistent with reason alone. Equity assists ignorance, but not carelessness. Equity assists no person to the injury of another. Equity never contradicts the law. Equity does not regard the form and circumstances, but rather the substance of the act. See, there are many nations without law, but you will never find a nation out there without maxims, sound principles and doctrines, ladies and gentlemen. So law is nothing without equity, and equity is everything even without law. That's the importance of these maxims. A small debt makes a debtor, a large one an enemy. Ladies and gentlemen, you are a bailor for the bailee. These people know this to be true. They owe you a large debt, which makes them the enemy of the people. They know these things. Your birth certificate is proof of the debt due and owing to you. All right? That's what that certificate is. It is one thing to possess, another to be in possession. An ambiguous pleading should be interpreted against the party offering it. He did this, or he did that, or he did this, or he did that. Ladies and gentlemen, that is vague and ambiguous. The law acts specifically, all right? It doesn't use a bunch of pronouns. It doesn't use a bunch of hypotheticals, ladies and gentlemen. It's specific. George kicked my dog, or he punched my dog, or he bit my dog. Well, what the hell did George do? Did he punch your dog, bite your dog? What did he do? You can't bring a claim vague and ambiguous before this court. An argument from a like case avails in law. An argument deduced from an impossibility is of great weight in law. The law permits the taking arms against the armed. An assignee acquires the rights of the assignor. Cease to reign if you do not wish to adjudicate. Consent constitutes law. Consent takes away error. The agreement of the parties make the law of the contract. An incorporated body has no heirs nor executors, nor can it die. A creditor who permits property to be sold gives up the pledge. That which, when given through mistake, can be revoked back when given with knowledge of the facts, becomes a gift. It is a fault to meddle with what does not belong to you. Time runs against the slothful and those who neglect their rights. There may be damage without injury. He who gives and retains testamentary trust gives nothing. Of things which do not appear and things which do not exist, the rule in legal proceedings is the same. Law assists the deceived, not the deceiving. Court or judges. Discretion is to know through law what is just. A deceiver deals in generalities. Deceit and fraud should always be remedied. In the same way in which anything is constituted, it may be destroyed. An error which is not resisted is approved. He who derives advantage from anyone should bear the person's obligation. An exchange naturally creates a warranty. He who comes out of his minority becomes legally a person. Extortion is a crime when by color of office any person extorts that which is not due, or above due, or before the time when it is due. That which is done cannot be undone. False in one thing, false in all things. Happy is he who has been able to understand the causes of things. Faith is an obligation of conscience of one to the will of another. Fraud lies hidden in general expressions. Things general precede, things special follow. Things general are not derogatory to things special. He who is the prior in time is stronger in right. Man is a term of nature, person of the civil law. Enemies are those against whom we declare war, or who declare it against us. All others are traitors and pirates. To speak insufficiently is the same thing as to say nothing. Ignorance of the law excuses no one, for all are presumed to know those things to which all consent. No one may come into court with unclean hands. In criminal cases, the silence of a person presumes consent. In civil cases, sometimes that of the person's absence, and even ignorant where his interest lies, does the same. In favor of life, liberty, and innocence, all things are to be presumed. He truly acts fraudulent who, observing the letter of the law, eludes its spirit. That's equity. Error dwells in general expression. In law, no one is credited unless he is sworn. In all contracts, whether named or not, an exchange is understood. It is unjust for freemen not to have the free disposal of their own property. A wrong is not to be presumed. Among many things, you will even question laws and learned men. A benefit is not bestowed upon one unwilling to receive it. A good judge may do nothing from his judgment, or from a dictate of private will, but he should pronounce according to the law and justice. A judge cannot punish a wrong done to himself. To a judge who exceeds his office, no obedience is due. It is the duty of a judge to decide according to the facts alleged and proved. It is the duty of the judge to declare, not to make the law. The law does not suffer the same thing to be paid twice. The unwritten, common law, is expressed by the tacit and ignorant consent and customs of the people. Right is threefold: of property, of possession, and of possibility. We are all slaves to the law, in order that we may become free. Witnesses should testify to nothing unless they are certain of it, that is, unless they have seen it or heard it. An unjust law is not a law. The mercantile commercial code is not merchant law, it closes. Law is the law of the land. So the mercantile law is not the law of the land. The law obliges no one to show what he is presumed to not know. The law does not require that which is apparent to the court to be verified. The law assists the ignorant. The name of the suit signifies every action, whether it be for a thing or against the person. Speak as the ordinary people, think as the learned. He must suffer in body if he has nothing in his purse. A guardian, state, ought not to make money out of the guardianship, citizenship of his ward, the people. That is a bad case wherein one tries to accomplish with money that which should be prompted by virtue. A maxim is so called because its dignity is chiefest and its authority the most certain, and because it is universally approved by all. Men are not included under the name of merchandise. Obedience is miserable where the law is vague and uncertain. It is called monopoly when one person alone buys up the whole of one kind of commodity, Federal Reserve notes, and fixes a price, income tax, at his own pleasure. We are ignorant of many things that would not be hidden from us if the reading of old authors were familiar to us. Multiplicity and indistinctness produce confusion and questions. The more simple they are, the more lucid. A multitude of ignorant persons destroys a court. It is more useful to impart a few trustworthy ideas than to impress men with many useless things. It is infamous to lay snares for the innocent through forms of law. A double negative is an affirmative. Denial cannot be proved. No one acts against himself. With security bond, no one is deemed a competent defender of the property of another. No one can rightly understand part of a thing till he has read through the whole again and again. No one should become condemned unheard or unsummoned, an essential element of due process. No one may be dragged from his house. No one should interfere in another's business in nothing relating to him. No one should be retrained in partnership supporting an artificial national debt with our credit against his will. No one should fill 2 offices. No one is compelled to substitute another in his own place. No one is beyond the law. No one is relieved or gains an advantage from his own proper deceit. No one can send anything into the domains of another. No one can be his own debtor. One is not present unless he understands. No one is presumed to be bad. No one is punished unless for some injury, deed, or default. No man ought to be his own judge or to administer justice in cases in which he, judges, retirement trust funds receive 11 cents from every $1 fined, is showing just one conflict of interest out of many is interested. No one is bound to arm his adversary against himself. No one who is ignorant is bound to give information, but everyone ought to know that of which he gives information. No one is bound to testify to his own baseness. No one is considered as defrauding those who know and consent. Nothing is so contrary to consent as force and fear. I think that's a big son of a gun. Nothing is so contrary to consent as force and fear. Nothing is so constant to natural equity as that the same thing be dissolved by the same means by which it is bound. An example does no good which settles one question by asking another. A name does not suffice if the thing does not exist either by law or by fact. He who errs does not consent. The reference is not to be credited unless the thing referred to be proved. It is not proper to surrender the person of men when no cause is shown. He who does not defend himself when present is considered as submitting. It is not law, but servitude to be held by what we have not consented to. There is no rule which may not fail. Name of things should be understood according to the common usage, not according to the opinions of individuals. Things should be judged by law, not by example. You are not to do evil that good may come of it. Not everything which is permitted by law is honorable. The necessity of proving possession of his property is not incumbent upon the owner. Not what is said, but what is done is to be regarded. The meaning of a word may be ascertained by reference to the meaning of words associated with it. A naked contract is where there is no consideration to support the agreement, but where there is a consideration and obligation exist and produce an action. No impossible or dishonest thing are to be presumed. Get away from me, you little son of a gun. Go. The good Lord might have created you, but I will whack your ass. You sting my toes. All right. No impossible. Oh, yeah. Why is it you want to fight me? Go away. There you go. Whack. The authority of no man ought to prevail with us, so that we should not follow better opinions, should another present them. No medicine is the same to all. No man can forfeit the right of another. Things abandoned become the property of the occupant. All men are either free men or slaves. Every definition in law is dangerous, for there is but little that cannot be overthrown. Every rule is subject to its own exceptions, and every exception is a rule. That law is the best which leaves least to be to the discretion of the judge. An integral part being taken away, the whole is taken away. Parties are presumed to know the law upon the undisputed facts of their case. It is not enough that sentences be given unless it be carried to execution. It profits little to know what ought to be done if you know not how it is to be done. Okay, that one's important. It profits little to know what ought to be done if you know not how it is to be done. How do I render payment? Just tell me what you're looking for. I had an alleged judge and administrator sit on a bench one day and tell me, Benjamins. So I asked him, where do I find Benjamins? I sure am curious. If you just tell me where to find them, I have no problem going and getting them for you. You see, I'm supposed to agree with thy adversary quickly and make right and remedy. So, you want Benjamins. Should I go around the neighborhood and ask people their names? And if I find a couple Benjamins, am I then and there authorized to grab these Benjamins off the street and bring them to you? Okay? No answer. Created an impossibility. Can't be remedied. It's immediately set off for discharge. The divine punishment of perjury is destruction. The human punishment is disgrace. Plain troths need not be to be proved. Witnesses are weighed, not counted. Presumptions are conjecture from probable proof assumed for purposes of evidence. Every jurisdiction has its own limits. He who contracts with another either is or ought to be not ignorant of the condition, of his condition. He who experiences the benefit ought to bear the burden. He who is silent does not thereby confess, yet it is true that he does not deny. Every man is presumed innocent until it is proven to the contrary. Where you doubt, do nothing. That which does not appear does not exist. The rule is that ignorance of the law does not excuse, but that ignorance of the fact may excuse a party from legal consequences of his conduct. In default of the law, the maxim rules. Money refused liberates the debtor. Everyone is the manager and disposer of his own affairs. It is a miserable state of things where the law is vague and uncertain. Let the principal answer. The answer of one witness shall not be heard at all. You ought to know with whom you contract. The necessity of proving is always incumbent upon him who acts. The presumption is always in favor of the one who denies. A presumption shall stand until the contrary is proved. Witnesses cannot witness to a negative. They must witness to an affirmative. The inclusion of one thing is the exclusion of another. An affirmative implies a negative. Laws should bind those who make them. Fictions arise from the law, not the law from fictions. The denial of a conclusion is an error in law. There is no disputing against a man denying principles. Against one denying principles, there is no disputing. Not far removed from brutes are those who are wanting in reason. Reason and authority are the two brightest lights in the world. Reason in law is perfect equity. Nothing which is against reason is lawful. Principles prove they are not proved. Plain truths need not to be proved. Every principle is its own evidence, and plain truths are not to be proved. Dissimilar things should not be joined. Doesn't mean they can't be, it means they should not be. You have to have your wits about you. Nothing similar is identical. What is like is not same. A person is a man considered in a relation to a certain status. The ignorance of the judge is the misfortune of the innocent. The ignorance of the law excuses no one, for all are presumed to know the things to which they consent. By ignorance, failures are increased. A good judge may do nothing from his judgment or from his dictate of private will, but he should pronounce according to the law and justice. Not to exist and not to appear are the same thing. What does not appear and what does not exist are the same. It is not the defect of the law, but want of proof. Bovier's Law Dictionary. To speak insufficiently is the same thing as to say nothing. He who alleges contradictory things is not to be heard. No proof is incumbent upon him who denies a fact. The proof lies upon him who affirms, not upon him who denies. The burden of proof lies with the plaintiff. He who affirms, not he who denies, must bear the burden of proof. He who affirms must prove. Consent constitutes law. Consent takes away error. Those consenting and those perpetuating are embarrassed in the same punishment. Perpetrating. Those consenting and those perpetrating are embarrassed in the same punishment. Long sufferance is construed as consent. It is better to suffer every wrong than to consent to a wrong. Nothing is so contrary to consent as force and fear. He who errs does not consent. I hope these things are helping you guys out here. And I read some of them last night, and the list just keeps getting bigger and bigger of the ones that are relevant. So there's duplicates. But I hope that this video will help kind of clear the fog from your mind while you're chasing remedy and statutes and codes and ordinances and stuff, because many of the maxims that I read from you actually come from the Bible. They come from Scripture. So it has been written, so it shall be done. That's Scripture, all right? And unfortunately for you guys that can't get this computer open, I have a list of other maxims that are just golden. One of them that I use all the time, and it's absolutely one of my favorite, is let justice be served though the heavens may fall. And it's such a powerful statement. So, with that said, I love you guys. I hope you were able to hear that. And I'll talk to you guys later.